Hi there. Welcome to another edition of CVN's Trial Technique Spotlight. For those of you who don't know me, my name is Shane Reed. I'm a former civil assistant United States attorney. I'm a trial consultant now. I've written a lot of textbooks on trial skills. Today, we're going to look at another example of how to ask for damages. And this is a continuing series we're doing right now on determining what is the value of damage to a person, whether it's minor, major, or catastrophic. Today, we got a fascinating case. It's Alexander versus Rojas. It's a 2023 case. And Keith Mitnik, the plaintiff's attorney, had a challenge. His plaintiff was a soccer star, and she'd been injured in a car crash and had pain and spasms, but it's kind of hard to define how permanent and really how much award for her damages. And another hurdle he had is the defense had done a surveillance video showing that the soccer star was playing soccer after the accident. So what was the plaintiff's attorney going to do? Well, he did something very brilliant. He put that surveillance video in context. We're going to watch about a minute and a half of it, and then I want you to think about how well he did, and then I'll share some of my thoughts with you on that.
I want to start with where we ended with the surveillance and the dancing. And here's why. We heard about brevity, and I'm all for brevity. There's no question. It'd been unfair to expect them to play 3 hours. I wouldn't have wanted them to. I might have squat. So I'm not criticizing for cutting it down. But there's another piece to brevity. There's context. I want you to look at this. She's on the bench. If you look at the times, she's over on the bench. It's like an hour and a half later, hour later, before she gets in the game. You don't see this when you see a clip of her in the game running around, throwing the ball, chasing the ball, defending the ball, whatever soccer players do. What you don't see is a star freshman the year before who was on a full scholarship with very limited scholarships. Second team all-conference as a baby freshman. Starter, designated team leader, who's now an hour into the game sitting on the bench before she gets into the game. An hour riding the tide. To the point, her mother, who drove all the way up here not to miss a game, home or away, to watch her daughter as a star, a rising star, she was embarrassed and didn't want her mom coming anymore. And her mom wouldn't come. She didn't want her mom seeing her sitting on the bench. That's what's not shown in this video. I started this opening statement, seems like a month ago, it was Monday, Tuesday, saying nobody said she couldn't play soccer. You're going to see her playing soccer. We played some of the clips of playing soccer. This case is a kind of injury where she's sitting in a wheelchair. Remember, I said her cane pain. That she can't do it. What she cannot do is do it at the level she did, and the price she paid cost her the scholarship they took the chance on. He knew she was hurt in a crash, was hopeful she was good enough to give one of those treasured scholarships completely to her, injured. That's how good she was. But she sat on the bench and could not perform at that level, lived in pain from continuing to try to live up to her personal drive, her personal goals, her personal ambitions and hopes and dreams, as well as a coach who had committed all that scholarship to her to push and play.
I think that clip has so many good teaching points. I don't want it to be lost on defense attorneys that surveillance video is always a really good idea. What the plaintiff's attorney did here that I thought was so effective is he put it in context, as he said. So the defense had shown just a part of the video, which I think was about 3 hours. But the plaintiff's attorney pointed out that the video that was shown to the jury actually showed the plaintiff only getting into the game after sitting on the bench for an hour. So this was a difficult argument of damages. but that she could no longer play at the level of excellence that she expected. And the enjoyment she got out of that, and the scholarship she lost because she was no longer the star player or the captain. And finally, this embarrassment factor. Her mother used to come to all the games and still wanted to come to the games, but the plaintiff didn't want her mother to ever come again because she was embarrassed. She could no longer compete at a high level because of the accident, because of the pain, because of the spasms she felt in her muscles because of the accident. And she was just riding the bench. And so she was embarrassed for her own mom to come. As a result of the plaintiff's attorney's arguments, the jury awarded a verdict of approximately $2.5 million. So check out the link if you want to see more about this trial. If you want to find more about my trial tips, check out my link below, and you can sign up for a trial newsletter that comes twice a month. And also check out CVN's vast libraries of other trials. Hope to see you next time.